Hello, my name is Brooke Benton. I'm a student here at GSW as well as a Pope Fellow. It is my privilege to introduce our next speaker, elder law attorney David McGuffey. David L. McGuffey is in a private practice with the elder law practice of David L. McGuffey, LLC, located in Dalton, Georgia, with a satellite office in Cartersville, Georgia. David limits his practice to elder law and special needs law. That means David helps elders, individuals with special needs, as well as their caregivers. Much of David's practice is devoted to helping individuals with chronic health conditions find, get, and pay for good long-term care. David has been a certified elder law attorney since 2004. David is AV rated by Martindale-Hubbell and is rated 10 by AVVO and is a Georgia super lawyer. In 2012, David was invited to join NAELA's Council of Advanced Practitioners, which is a premier group limited to NAELA members in practice more than 10 years who are AV rated and who are either CELAs or NAELA fellows. David is also a member of the Special Needs Alliance, which is a premier invitation-only group of attorneys dedicated to the practice of disability and public benefits law. David speaks and writes extensively on elder law and on special needs law issues. Many of his publications are available on his website at www.mcguffey.net. Please welcome David McGuffey.
Am I on? I was muted earlier, so it's nice that you can hear me. If I've been told that I'd speak softly at times, so if you can't hear me, yell out or throw something at me, and I will try to speak up. I'm no Mike Daly. You're stuck with what you got. That was one of the most moving talks that I've heard in a while, and I'm honored to follow you. I hope I can do this justice. I'm going to be using a number of stories to illustrate to you some of the issues that you need to think about as a caregiver or as someone who is in the community and just cares about your stuff and your family. Johnny is the child of two of my clients. And Johnny recently was thrust in the role of serving as caregiver or for both of his parents. And one of the problems he had was finding information. So I would tell you, if you're on the cusp of doing caregiving, or if you see that as something to be concerned about in the future, or just for yourself, I would compile information. There are many tools out there you can use. Many financial planning websites will have tools that you can use to pull together information, and I would put it in a safe place. Obviously, you don't want a thief getting your private information, but if you're in a situation where you can no longer manage your finances or your business, you're going to want someone who can help you, or the person that you've selected to help you finding that information. Things that are critical, health insurance information. Who are we submitting health insurance claims to? Where is the life insurance? Who are the beneficiaries on the life insurance? Where are the legal documents? And those legal documents that Mike was talking about are like keys. And if you notice, on any key ring, you probably find more than one key because they serve different purposes. The document that Mike was talking about, the financial power of attorney, that is a critical document, and many people don't execute those documents early enough because they're fearful that they'll be abused, and they can be abused. But there are ways that we can limit the effect of those documents and hold them until the right time. A power of attorney is like the key that opens the lock, allowing someone to manage your financial business. In Georgia, we changed the law effective July 1, 2017, So now a financial power of attorney must be specifically initialed for certain actions. For example, if you want your agent to be able to change beneficiaries on your life insurance, that requires specific authorization in a power of attorney now. Old documents were kept. The legislature did not provide that old documents become ineffective, so if you had an old document, it's still effective. But any new document, you would have to make sure that you dot the I's and cross the T's, or you're going to be in a situation like one of my clients was in recently. We had a life insurance policy on the life of the community spouse. Now, what is a community spouse? Mike Daly is a community spouse under federal Medicaid law. That's a defined term. But the policy that my client had left the life insurance proceeds to the institutionalized spouse, which would be Mike's wife, and we don't like that result because that would cause problems with Medicaid if Mike predeceased his wife. So we wanted to change the beneficiary. Now, there are different ways we can change the beneficiary. We could simply bypass the sick spouse and leave the proceeds to a child, or we could do what I'm guessing Mike did, and I'm not going to ask you in front of this crowd. Many times what we will do is set up a special needs trust to take care of the sick spouse or a disabled child after the healthy spouse is gone. We couldn't get that done without going out and getting a new power of attorney because, as I said, the law changed in July of 2017, and now we had to have a power of attorney that gave us specific authorization to do that. So Johnny's story first is find the information. Where's the stuff? And then I want to tell you about Larry's story, which is probably somewhat reminiscent of what Mike went through. I have a CPA friend who for years has been telling people that spouses specialize. And one of the problems you have when one spouse gets sick or one spouse dies is they take that specialized knowledge with them. And in his case, because he was a CPA, he did most of the family finances, but his wife knew how to set the laundry. His wife knew what their children liked for Christmas and birthdays. His wife knew all of the favorite foods. And so they each did a tape recording for the other. And these days, that's easy to do. He used to talk about using a cassette recorder because all you have to do is hit the button to turn it on and start talking. But these days, you can take out your phone. I've lost mine, there it is. And most phones have a recording app, which you can, if you've got the premium version anyway, you can email to yourself and save that as an audio file. And you can update it regularly if you need to. That is one way to deal with telling other family members where's the stuff. You could just make a recording if you don't want to fill out a form. But that kind of information needs to be preserved, and it needs to be shared. And my CPA friend told me about the time when his wife thought he had died, and she was looking for the recording, trying to find it. And thankfully, he made it home, and she didn't have to play it. Now, another one of my clients has a different story, and I'm sure that some of you have already struggled with this. Mark and Bob. Mark is a son, and Bob is a dad. And Dad has dementia. And one day, Mark's sister called him up and said, "You've got to go take away the keys. Dad can't drive anymore." And Mark said to his sister, "I'm not going to be the bad guy. If you want to take away the keys, you can come do it yourself." Well, there are a lot of different issues packed into that conversation. One of the first issues that we have to look at is the concept of capacity. Does Bob still have capacity to drive? And we don't know the answer to that. Maybe he does, maybe he doesn't. And if he doesn't, we need to get him off the road. Paternalism is something that I see frequently when I'm working with children of aging parents. The children want to take care of their parents, but sometimes they overextend themselves and they impose their values on their parents. They try to take over before it's time. And that's something that could have been going on in Mark and Bob's story. I don't know. But we have to look at that carefully. If we've gotten to the point where Bob should not be driving, though, the Georgia Department of Driver Services can be the bad guy for you. Any relative or other interested person can send a non-anonymous letter to the Georgia Department of Veterans Service, Georgia Department of Driver Services, and they will require a medical review. There is a form you can use if you don't want to use the letter. It's form DDS-270. If you Google that, you'll probably pull it right up. And that form, if you fill it out, would also generate an administrative review of someone's driver's license. The way it works, the Department of Driver Services sends out a letter requiring the driver to submit for a medical or vision review. And if they fail to submit to it within 30 days, then their driver's license will be revoked. So that's one way to let the state be the bad guy. There is another tool that caregivers can use, and that tool is an agreement that you would enter into with your parent or with your child, if you are the parent, where you agree that when it becomes unsafe for you to drive, you will turn over the keys. There is a good booklet on that that is done by the Hartford Insurance Company. And if you Google that, you should be able to find it. The agreement to stop driving is in the back of that book. So those are some of the issues that came up with Mark and Bob's story. Capacity, legal capacity, is one of the things lawyers struggle with regularly. When Mike was saying that you've got to do these documents early, what he was really talking about is doing them while the individual still has legal capacity. There will come a point when an individual may lose legal capacity, but it's not like one of those light switches in the back of the room. It's not where you flip it on or off and the lights are either on or off. Capacity is a continuum. And even after a diagnosis of Alzheimer's or some other dementia or any other disease that robs you of your faculties, you can still execute documents if you know what you're doing. What I look for as an attorney when I am evaluating whether someone is having a lucid moment, and it can be a fleeting moment, I'm looking to see whether they know their family, whether they know who they are themselves, and whether they want this person who might be their agent to help them. And if they can combine those concepts, they probably have legal capacity. In Georgia, the ultimate arbiter of legal capacity is a probate judge. In other states, it might be a different judge. But in Georgia, we have 159 counties, and if we need to make a final determination regarding whether someone has legal capacity, it would be in the context of a guardianship or a conservatorship. The judge is ultimately looking to see whether the individual can make or communicate significant decisions. It's divided into two parts. The first is make or communicate significant decisions about your person. Medical decisions, housing decisions, who we're going to see or not see. The second part is make or communicate significant decisions about finances. In Georgia, we call that half of the process the conservatorship. The half where we're talking about personal decisions is the guardianship. The action is usually brought at the same time. So usually, if we're determining capacity, we're going to go ahead and decide the personal issues and the financial issues. Most probate judges would tell you, though, that the number one problem or the number one defect that people bring is filing the action too soon. And the reason why I say that is because if we get to the court and the judge hears from the person that we're seeking to impose a guardianship on, and it sounds like they can make their own decisions, it's not whether we agree with those decisions, it's whether they can make those decisions. I interviewed Professor Mary Radford several years ago when I was putting together a program on guardianship and conservatorship. And the reason why she was significant is because she served as reporter for the Georgia legislature when they rewrote our guardianship statute in 2005. And she gave me this illustration. Consider an older gentleman who for years had been tithing to his church. And he was generous with his money, but he was also conservative. And then, for inexplicable reasons, he stops tithing and starts buying porn. We would not seek a guardianship because he's buying porn, if he knows that he's buying porn. We would seek a guardianship if he doesn't know what he's doing. There was a case in Georgia that was decided several years back where someone was, they were trying to impose a guardianship because someone was buying into these lotteries or giveaways that you see out of the Caribbean and Africa and other places where we all know it's a scam. And the court was evaluating that, and the court very clearly stated, so this is Georgia law, that the issue is not whether the person is sending their money to a scammer. The question is, do they know they're sending the money to a scammer? And if they do know it, then a guardianship would be inappropriate. So legal capacity is something that we're looking for before we do any of these documents. It's the starting point. It's where we begin with all of our decisions, because everyone is presumed to be autonomous. Everyone is presumed to be the captain of their own ship. If I have legal capacity, and if I like Mike, I can name Mike as my attorney-in-fact. Now, Mike would probably tell me he's got enough on his shoulders and he doesn't want that job, but I could name him as my agent, and if he chose to do the job, then he would have power under that document to act for me. It's, again, the key that opens the lock. If I have legal capacity, I can execute an advance directive. In Georgia, we no longer use the old forms of living will and healthcare power of attorney. Effective July 1 of 2007, our legislature combined those documents into a single form. We call that a healthcare advance directive or an advance directive for healthcare. There's no magic to which order you put the words in. The document will allow someone to make health decisions for you, healthcare decisions for you, if you name a health agent or a health proxy. The document will also allow you to state what your wishes would be if you had a terminal condition or if you were in a persistent vegetative state. When should you execute this document? Well, let's turn to Terri Schiavo's case and think about it. Terri Schiavo was born in 1963, and she got married in 1984, I believe. And in 1990, believe it was February 25th of 1990, Terri Schiavo had a cardiac arrest as a result of a potassium imbalance. She was 27 years old. There were at least 4 trips to the Florida Court of Appeals, at least 1 trip to the Florida Supreme Court. The U.S. Supreme Court considered the case, but I believe they denied cert, so it didn't go up. It was debated on the floor of the U.S. Senate, where Senator Bill Frist substituted his judgment for that of the doctor overseeing Terri's care. And every bit of that could have been avoided if Terri and her parents and her husband had had a conversation about what Terri wanted, or if Terri had filled out a healthcare advance directive. So what's the right age to do one? On your 18th birthday. That's the right age to do a healthcare advance directive, because no one knows what's coming next. I have a crystal ball in my office and it doesn't work. And I guarantee if you have one, it won't work either. No one knows what tomorrow is going to bring, so on your 18th birthday, or as soon thereafter as you learn that you should do one, you need to execute a healthcare advance directive. And how many of you live in Georgia? None of you have an excuse, even if you hate lawyers, because if you Google Georgia Healthcare Advance Directive, you're going to find one on every law school website. You're going to find one on the Department of Human Services website. You don't have to pay a lawyer to execute this document. You might have to pay a lawyer to explain it to you if you don't understand it, but you don't have to pay a lawyer to execute it. So you don't have an excuse. Your children don't have an excuse. Your parents don't have an excuse. If you live in Georgia, you can do it for free. And if you can't find it on any of those websites, it's on mine. So what really went on in the Terri Schiavo case? It was different from the cases that preceded it. The Quinlan, never can remember how to, Quinlan. The Quinlan case was decided in New Jersey in 1976. Ms. Quinlan stopped breathing and was deprived of oxygen for a long enough period of time that she had permanent brain damage. When her parents tried to terminate life support, the state opposed them. And that ended up being one of the early cases where we considered what to do in an end-of-life situation. And the court in that case applied a substituted judgment rule. And they looked to see what would Ms. Quinlan have wanted if she were awake, if she could wake up and consider the fact that she would never have a normal life. Much of her brain was not functioning. It would never function. And the court decided that her parents could make that decision for her. The Krizan case followed it, and these are good cases to think about in caregiver terms, because a lot of caregiving is learning how to be the decider. First time I heard that was, I believe, George W. Bush saying that he was the decider. I love that word. I think he invented it. But many caregivers have to be the decider. They have to make these hard decisions. And in the Krizan case, the U.S. Supreme Court ended up ruling, and in that case, the Supreme Court recognized that The informed consent is the bedrock of how we make decisions in the United States, and the logical corollary to it is the right to refuse treatment. And the court went on to cite a Massachusetts decision where it indicated that the state's interest in preserving life is greatest when an affliction is curable, but is lessened when the issue is not whether, but when, for how long, and at what cost a life may be briefly extended. And ultimately, the Supreme Court held that we can make those end-of-life decisions. We can refuse care. In that case, though, they said that the state of Missouri could require clear and convincing evidence of what Ms. Kruzan would have wanted. Well, what is the best clear and convincing evidence of what any of you would want? To execute a healthcare advance directive and specifically state what you would want. One other thing you can do, there are many booklets out there. Critical Conditions is one. I believe Five Wishes has a similar section in their booklet. You can complete a health values questionnaire. That is a more extensive document than a healthcare advance directive. It might say what you would want if you were diagnosed with cancer. Would you want chemo? Would you want radiation therapy? If you already had a dementia and you then had an overlapping cancer diagnosis, if you filled out one of these health care worksheets, health values worksheets, you would not only be able to tell your family what you want, so you take the burden off of them. Now they know what you would have wanted. But you can also tell the healthcare community and, if necessary, the courts what you would want, which gets us to the clear and convincing evidence threshold that we are looking for. Now, in Terri Schiavo's case, which followed those two cases, we already had this framework of what we're looking for. The problem is Terri never told anyone what she wanted. So when Michael Schiavo, in 1998, 8 years after Terri had this catastrophic healthcare event, when Michael Schiavo went to the court and became Terri's guardian, one of the first things he wanted to do was turn off the machines. And the Schindlers, Terri's parents, went to court and objected. The Schindlers said, no, that's not what Terri would have wanted. Terri would want to live. Well, the court looked at that case, and the court initially found that Terri would not have a life worth living because of the advanced state of her brain, being in a coma for, at that point, 8 years, almost 10 years by the time it got through the court system. Deterioration of her brain. The court agreed with Michael and agreed that he could turn off the machine, and that's when the appeals started. So that's another reason why we want these documents in place. Even if you have a fiduciary, a guardian, or a health proxy that has legal power to turn the lock, use the key to turn the lock, you can have someone second-guessing them. You can have backseat drivers who are saying, no, 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 you're abusing your authority. And having the document in place would answer the question the court is going to ask, which is, are you doing what Terri wanted? Or in the case of your parent or whoever you're caring for, are you doing what the patient would want? Because ultimately, it's the patient's values that we're supposed to be following. So Terri's case illustrates a number of things. It tells us that we need to get the documents in place. We need to have conversations. It also tells us if you think someone is abusing their authority, you have recourse. You can go to court. And if you have a specific set of values that would cover different circumstances, it might be good to do one of these health values worksheets so that we have some evidence for the court to consider. Another thing, I love stories. I was fascinated with yours. I've got a friend who lives in Dalton. That's where I am from. I'm doing my best caregiver impression this morning, by the way. I had a number of things that happened in my office this week which caused me to miss the meeting last night. So I got up at 2 a.m. to drive down here from Dalton. And if you're a caregiver, you probably feel my pain every day because you're probably running on empty every day. But I love stories, and this week's episode of The Rookie had a scene in it where Officer Nolan, he's the star in that show, was trying to prevent someone from committing suicide. And he pulled out a lottery ticket. And he said that he had been on the edge years before where he had lost his business, lost his wife, lost his money. And he was in the liquor store and he was about to buy the biggest bottle of liquor that he could find, but he ended up buying a lottery ticket instead, and he said it saved him. He didn't win, but it gave him hope. And hope is something that we have to remember when we're working with caregivers. We need to give people hope. And a lottery ticket might be a poor crutch to use for that, but he said he bought one every week because it would give him hope for a few more days. And by the time that this scene had come up, he said, I don't need it anymore. Here, take it. Take some hope. And he ended up saving the person. I thought it was a great story. If you're ever in a situation to give someone hope, though, who is a caregiver, I would suggest that you do it, and do it abundantly. One of the things that we try to do in my office is give people peace of mind. When someone comes in, like Mike was describing, where he discovered, much to his amazement, that caregiving is expensive once you start getting help. One of the first things we try to do is help people by giving them peace of mind. We try to take that off the plate. In Georgia, Medicaid will help people get care in the home up to about 30 hours a week with the Community Care Services Program. There is a waiting list for that, though. And Medicaid will also pay for nursing home care. A certified elder law attorney, such as myself, can almost always protect what the marriage has for someone like Mike. Now, in New York, they used a process that we really can't use here called spousal refusal, because Georgia does not give credence to that, even though it's in federal law. Georgia says, you've got the money, we're just going to deny you Medicaid unless you pay or spend down. I've gotten away with that in a couple of cases where there were estranged spouses, and we were able to push it through. But 99 times out of 100, that won't work in Georgia. So we do different things. Recently, I was able to protect a person that I value. I value all of my clients, but this one in particular I value because he was a veteran. And I love sitting in the nursing home with him and talking with him about history. He's a history buff. And I value him enough that when I make chili, I take it to the nursing home. And it was exciting. He actually asked me to cook some more and bring it back. So apparently I I did an okay job for him. But when his wife initially came to me, she was frantic. She had never managed the money during the marriage. She was just basically yelling, "Help me, help me." And we were able to help her. We were able to protect their house, protect about $700,000 that she will need for her own retirement, and if she gets sick, for care in the home or for assisted living care or for other needs. And we were able to get Medicaid to pay the bills. That's probably a case where I saved more money than I usually do because most of my clients don't have that kind of money. But I say that to illustrate my point when I say that we can almost always protect the healthy spouse if there is a marriage. Mike mentioned that someone told him to get a divorce. You can do that sometimes. I've probably done 4 or 5 Medicaid divorces, but I generally avoid that, except that I'm doing it now because I have a client where both spouses are in the nursing home. And right now we're paying 2 nursing home bills, and by getting a divorce, we can cut that in half. And what it does is it allows us to save some of the resources to buy things Medicaid won't pay for. If you think that Medicaid is generous, then let me use the following illustration. Medicaid, in its most generous class of assistance, the nursing home class of assistance, will pay for food, shelter, and medical care. Can you think of another government program that will do that? Try prison. So in its most generous form, Medicaid is a prison-level benefit. That's why we protect money to help the person in the nursing home and to help the community spouse who still has all of the same expenses they had before their loved one went to a nursing home. Because we don't want people to live at a prison-level benefit. Now, I told you a number of stories. I will, before I open it up for questions, by the way, if you didn't catch it, I was describing Medicaid. So if you have Medicaid questions, you can throw those out as well. But before we open it up for questions, I want to tell you one more story. And that is Busilla Stevenson's story. In 2009, when she was 89 years old, she executed a health care, at that time it would have been, health care advance directive. That was after the legislature changed it. She appointed Jacqueline Alicia, that's her granddaughter, as her health agent. And then we rocked along until 2012 when she had a stroke. And she was taken to a hospital, and Ms. Stevenson had always said, when my time is up, don't drag things out. I'm ready to go home to the Lord. She expressly voiced her values and her desires, made it clear to her family what she wanted. So when she went to the hospital, her granddaughter, the health proxy, said, do not put her on a ventilator. Do not intubate her. The doctor decided that he would make decisions on his own. He would ignore what was in the chart, and he put Ms. Stevenson on a ventilator. Ms. Stevenson's granddaughter's husband came by the hospital around 8 a.m. after they had done this at 6 a.m., I think. And he discovered Ms. Stevenson on a ventilator, immediately called his wife. She came down to the hospital and started asking, why was this done? When the nurses looked at the chart and said, someone really screwed up, the granddaughter started raising Cain, and they took Ms. Stevenson back off of the ventilator. She died a few days later. The result after that, the granddaughter, Miss Alicia, filed a lawsuit. It went up to the Georgia Supreme Court, and I don't know if it would ever turn into any money, but the Georgia Supreme Court said that lawsuit can go forward where the agent is seeking damages because the doctor ignored the patient's values, the patient's desires, as expressed through the health proxy. I was told to leave time for questions. I think I have given you plenty of fodder to think about, but let me say that before we start asking the questions, the three main documents that everyone should have, I've talked about two of them, the power of attorney, healthcare advance directive. Everyone needs a will. Even if you don't think you've got anything of financial value, you might have things of sentimental value. I am not rich. I've been divorced 3 times, so I'm pretty much broke. But I have my Aunt Mary's quilt, which she hand-stitched with her daughter's clothing after her daughter died in the Winecoff hotel fire. It's one of a kind. It's a family heirloom, and I care who gets it. So I need a will. That's the kind of stuff you can put in your will. If you've got money or vehicles or land, or if it's just Aunt Mary's quilt, you need a will. Do we have questions?
So one question is, how do end-of-life decisions impact life insurance?
They don't. The Georgia statute expressly provides that exercising a healthcare advance directive and using that to terminate life will not impact life insurance.
Okay, what is the most common issue or issues that military families and their caregiver come to you for?
People who are in the military will frequently look for a non-service related pension that can be used to help fund assisted living care, or can be used to help pay for home health care. That benefit is called aid in attendance. I have the paper that I prepared, which I don't know how you're going to get, but I know it's going to be available for everyone. Has a section on the new rules. The aid and attendance rules changed effective October 18th of this year, so this month. And so you can look at that part of my paper, but that is the number one reason military families come to me when we're talking about long-term care. They're trying to get help paying the bills.
Okay. Dependent or not, is there a worry that the state could come after my assets?
Worried the state can come after your assets. Well, you didn't hire me, so that's why. What I would do is tell you that you should probably look for an attorney close to you. There are some attorneys that will tell you they can handle cases all over, and technically I could handle any case in any part of Georgia, but you lose something if you try to do that. You lose that connectedness that you would have with your attorney, or that sense of trust that comes from spending time with them and seeing them face to face. So I would probably err on the side of finding someone that's close enough to you so that you can meet with them on a regular basis. And if you go to the National Elder Law Foundation website, that's NELF.org, you can find certified elder law attorneys all over the country. That's what CELA stands for, certified elder law attorney. Or if there's not a certified elder law attorney near you, you can go to the National Academy of Elder Law Attorneys website. That's naela.org. And both of those websites have a find a lawyer tool.
If you write and sign an advance directive, why do you need a health agent? What's the difference?
If you have executed a healthcare advance directive, you probably named a health agent or a healthcare agent. In Georgia, technically, you will have a health agent whether you do one or not. We have a default statute, which is covered in the materials. Number one on that list is you for yourself. Number two on that list is whoever you named in a healthcare advance directive. And then we go on down the line. One of the problems with the default statute is when we get to adult children for a parent, what if they don't agree? So it's better to name your health agent, and you would actually name them in the healthcare advance directive.
Okay. I have separate living will and healthcare power of attorney agreements because they were drawn up before 2007. Do I need to get new ones done under the combined form?
The documents you did prior to July 1, 2007 are still effective. The problem could probably very well be that your values have changed. You know, when I was younger, I felt like Superman. And now that I'm 53, not so much. And my values have changed along the way, and I suspect as I head toward 73, they may change again. And the person that I named as my agent when I did the documents before, maybe they don't live around me anymore. Maybe they died. So it's a good idea to update those documents regularly.
Okay, and if you are a caregiver to your adult development disabled, should you do any legal?
Caregiver for
Your adult development disabled.
Okay. If you are caring for someone who is a disabled adult, I am assuming that the person who wrote that question might be talking about a child or a sibling. Some of the things you need to think about would be, do I have a special needs trust in place? Here's why. When you die, you're the caregiver, right? When you die, we probably have to hire somebody to replace you. One of the things we probably want to do is put a term life insurance policy in place on your life and point it toward the special needs trust. The reason I say term is if you're like me, you can't afford whole life. Term is usually cheaper. And then when you die, we have money to take care of this person, this adult disabled child or sibling, and we can go out and hire caregivers. And because it's in a special needs trust, it will not impact eligibility for SSI or Medicaid. I would also think about, I frequently do guardianships for parents who have a child turning 18, because if the child cannot execute a power of attorney, that's the first thing we look for. Can they execute a power of attorney? But if they can't, then once they turn 18, we need someone to make healthcare decisions. We need someone who can access medical records. We need someone who can continue to talk to the school system if we're still getting services.
That's all that I have. Okay. Where should people turn other states look use similar info? To look for similar info, I'm guessing.
Okay, if you're from a state other than Georgia, and actually Tennessee too, because I'm admitted to practice in Tennessee, but if you're from a different state, you're going to want to find someone in the state where you're living that does elder law. And the first place I would start is with the National Elder Law Foundation website, that's nelf.org. And then I would peruse the websites of lawyers in those states and see what those lawyers have put on their website, because many of them will have information. You can also look for books that are at Amazon.com. There are many lawyers out there that will lend their name to a book. I don't generally do that because I write my own. But someone might write a general book on Medicaid, and then they would reach out to a lawyer in Florida to say, write the Florida section of this, or whatever your state is, and then that would be available at Amazon.com. You can also, surprisingly, now if you go to YouTube, you would be shocked at how many lawyers have put videos on YouTube. And just search, use the different search terms that would be necessary to narrow the focus of your search, like Georgia and special needs trust or something like that. And you'll probably find YouTube videos that would help you understand the topic that you're trying to understand.
Okay, thank you.